we had, by 1948, the basic laws of human rights. We'd worked out the basic rights of individuals to be treated properly and fairly. Of course, on an international level, they went into the deep freeze of the Cold War. And we got wonderful conventions. We got conventions against racism and against maltreatment of women, against torture, against apartheid, the good conventions, but they never had any enforcement mechanisms attached. And of course, that is why, as someone said, surveying the killing fields of Rwanda, the road to hell is paved with good conventions. They didn't have any kind of enforcement, and we never delivered on the promise of Nuremberg until just before the end of the 20th century in which 160 million people had been killed in war and in genocide. Finally, we got the Pinochet case, we got the International Criminal Court Agreement, we got the ICTY and ICTR, the war crimes tribunals in Rwanda and in The Hague for Yugoslavia, actually starting to punish important people, the concentration camp combatants, the generals who were responsible for Sarajevo and Srebrenica and so forth. And so, slowly, we've got now Karadzic and Taylor, both heads of state, both on trial. Very late, Pol Pot's lieutenants in Cambodia, better late than never. So the promise of Nuremberg, the great principle that those violators of human rights will be punished, is at least underway. But what about the national measures that the Universal Declaration requires, the national measures to protect human rights? Well, here we come to the question that I've written this little book about, the Charter, the Bill of Rights. On what basis do we need a Bill of Rights to bring the human rights principles back home? Well, this penny dropped in Britain in the 1990s. The common law that has some great protections in it, habeas corpus and so forth, was increasingly found to be inadequate to the task of protecting human rights in the 20th and 21st centuries. This was discovered in Britain by virtue of the fact that Britain signed up to the European Convention on Human Rights. It had a court of its own, and it suddenly found time and time again in cases where it's the common law of libel, the common law of contempt, breached the principle of freedom of information, where the treatment of prisoners was ill treatment, inhumane treatment, where in so many cases the common law was inadequate as a basis for the principles of fair adjudication. And so in 1998, Britain passed its own Bill of Rights. It made as part of its law the principles of human rights that are basically those in the Universal Declaration, although they came in through the European Convention. America, of course, had its Bill of Rights, and we have all seen what that has produced. President Obama is the creation of a Bill of Rights, of Brown versus the Board of Education and the great cases that argued for equality in education and other matters. Germany, after the war, as a protection, hopefully, against the resurgence of fascism, had its own Bill of Rights. South Africa, after apartheid was overthrown, developed and drafted and imposed a very modern Bill of Rights. Even New Zealand, finally, had a Bill of Rights, but Australia doesn't. And in Britain, after 10 years, it has seemed to me, and I set out the evidence for this in the book that the fairness and justice in society, particularly to those who, well, lawyers call them ordinary people, which is a condescending phrase to refer to people who aren't lawyers, but they are the greatest beneficiaries. They are people who've been treated unfairly by public servants, by bloody-minded bureaucrats, in ways that without a Bill of Rights they'd be able to get away with. Because human rights is based upon human dignity. That was the great thing about H.G. Wells's Bill of Rights. It refused to countenance the idea of human rights as inalienable, as God-given, as natural. It said because a man is brought into the world through no fault of his own, he's entitled in justice to these particular rights which it enumerated, and that has been the principle on which modern bills of rights are based. The idea that individuals, as Immanuel Kant said, should do unto others as they expect to be done unto them. Its human rights is based upon human dignity, and bills of rights apply in hospitals, in old people's homes. We've had numerous cases of, and what is so remarkable, I think, about the reality of the way the Bill of Rights has worked in Britain is that after 10 years, we're seeing cases simply don't come to court, but they're cases where people themselves, often hospital consultants or nurses in old people's homes and so on, are able to invoke the principles of the Bills of Rights to stop humiliating or disrespectful treatment of individuals. There are cases like the family who came to see their grandmother in an old person's home. Because of the convenience for the staff, she was made to eat her breakfast while sitting on the toilet. Appalling. And they invoked the Bill of Rights, and immediately that sort of behavior stopped. There was another case of a care home where a couple who'd been together for 60 years were put in separate care homes. Incredibly humiliating and disrespectful of them. The Bill of Rights was invoked and that was stopped. And in hundreds of ways, these minor but to individuals incredibly hurtful and disrespectful behaviors, which often imposed by public servants for their own convenience or unthinkingly have been stopped in Britain. Do those sort of things happen in Australia? Well, you betcha they happen. I have a friend whose father had a stroke, was rushed to hospital. He was a former captain in the Australian Navy. He had my most cherished possession was his beard, his naval beard. As soon as he got to hospital, they shaved it off without asking his permission. New South Wales Hospital, I don't know whether that sort of thing is done in Queensland, but a simple disrespectful action done. Oh, well, we don't, he's in hospital, there's a rule against beards, we just shave it off. In New South Wales, you have to, when you're in your 80s or 70s, have to do a driving test. And a man I know, courageous ex-fighter pilot, been driving for 50 years without a blemish on his license, just loses it once, that's fine. But you know what they do? They cut it up in front of your face. They have a pair of special clippers and the plastic is cut up in front of your face. Well, how unnecessarily humiliating is that? There are dozens of examples people have been telling me where just unthinkingly disrespect, particularly for the aged, but also for the mentally ill. There was an extraordinary a report a few years ago by Brian Burdekin and the Australian Human Rights Commission about the way mentally ill people were treated and mistreated under human rights principles. So at this very basic level, bringing human rights home means a more respectful treatment to people who are vulnerable, not because of what they've done, not because it's blameworthy, but because they are aged, because they are mentally handicapped, because they are children. You get these rules that need to be tested and in many often revised by reference to human rights principles. You see, a lot of people who bash bills of rights and how easy it is for talk in headlines about bills of wrongs and so forth, they think that only the people who get anything out of them are prisoners or immigrants, refugees, the people we love to hate. Well, it's the test of a decent society, isn't it? How basically humanely it treats its most vilified or most vulnerable members. So I don't rate that as an objection, but the reality is that the real beneficiaries are all of us with children, with aged parents, and so forth. It does add measurably to the degree of civility in society. Of course, when you read about the Bill of Rights, it's always in test cases at seemingly very important levels. The great question that is often referred to is the question of indefinite detention, because when the indefinite detention of suspected terrorists was an issue in Britain, the highest court, by 8 votes to 1, decided that Magna Carta, the whole British tradition of liberty, meant that you could not detain someone forever without offering them a trial. When the same issue came before the High Court of Australia in a case called Al-Kateb, the High Court of Australia decided 4-3 that it was perfectly all right to detain someone forever, if need be, because that's what Parliament seemed to have said in the legislation. One of the judges, Michael McHugh, said that he wished he didn't have to come to that conclusion, but in the absence of a Bill of Rights, he had no alternative. So that they are, of course, cases at a high level. There are cases, I think, so many in my experience of a Charter of Rights where it works for you and I, for people who aren't lawyers. Of course, in Australia, there has been this particular slant. In fact, when the Rudd government announced its consultation, there were headlines in The Australian, which is a paper that has decided editorially that bills of rights are bad things because they create, and I quote, banquets for lawyers. The interesting thing about this argument is that the kind of lawyers who activate bills of rights are, in fact, people working in law centres, in trade union offices, in Aboriginal law centres. In Victoria, there was a great case brought recently by the Human Rights Centre there by lawyers who earn even less than cadet journalists. And those lawyers took on a case where the Victorian state government had ruled that kids who had autism were not mentally affected that they needed special treatment in Victorian schools. This was a ridiculous decision and on any view, but it was the decision the government made. And those lawyers challenged it, and at the door of the court, the government conceded and decided that children with autism would, thanks to the Human Rights Act in Victoria, would get special treatment in schools. So again, the argument that, oh, lawyers will make money out of it, ignores the fact that there are very different kinds of lawyers. There are lawyers at the commercial end of town who deal in tax and in commerce and in corporate law. Not much call for human rights there. They're the lawyers who make the money. There are lawyers who, for one reason or another, decide to work for the poor and disadvantaged. They are lawyers on a very low salary. And of course, the great thing about a Human Rights Act that we're seeing increasingly after a decade in Britain is that you don't need lawyers at all. That while the principles of human rights are better known, then they are there for hospital consultants, for nurses, for other professional people to invoke when people are treated badly. And so cases that work do not come to court. The other great advantage of a Human Rights Act, and this is why I've drafted a charter, as it were, for Australia, which does... I don't suggest by any means that my drafting is anywhere near as good as others, but it does enable our children to be taught the real values that people in this country over 2 centuries now have struggled and fought for. My bill begins with Arthur Phillip's first law, the first law that he wanted the nation that, as I said, only he ever thought would become a nation to have against slavery. And then it goes on to pick up on particular proud moments in Australian history that can be taught to children. We are now, thanks to an experiment in Canada, where they started in schools in one province of Canada, teaching human rights in terms of citizenship, and now that was trialled in a county in Britain. And from next year, the course is going national. Every child in every school in age between 12 and 14 will undergo a term course that will be begins with us questioning what human rights are all about, teaching human rights, applying human rights to, they start by a new set of school rules that teachers may confiscate mobiles and keep them and so forth, trying to work out why these new rules are unfair. And then they learn the history of human rights. They take a case, homophobic bullying, actually, which is a problem in many schools here, I suspect, as much as in Britain, that they do hypotheticals and tests and so forth. And at the very end, the last thing they've got to do is to go out and exhibit some interest in human rights in practice, to write a letter to a newspaper, write a letter to their MP, fundraise, make a film, call a callback radio show. It'd be great if Alan Jones were flooded with school children for their final test, talking back to him. So I think that by other reason, actually, for one of the important reasons for advocating a Bill of Rights is not actually to improve the level of respect and civility in society, but to use it as a basis for teaching civics and teaching national identity and being proud of not only the history that Arthur Phillip brought to this country under the old principle that you bring the law of the conquesting country to the new country, but our own achievements over 221 years in human rights. I think it's nonsense, as I've said, to complain about unelected judges. Judges are not elected, precisely so they can be independent of Parliament, and that's been the role of the judiciary since 1642. They're charged with safeguarding the liberty of citizens, and the British experience shows that a charter equips them to do that job more effectively. They can't do it. People say, oh, what about Zimbabwe? Well, what about Zimbabwe? They've got a Charter of Rights. The judges were terrorized by Mugabe's thugs and sacked, and they were replaced by judges whose, on coming into office, they were given a farm that had been taken from a white farmer. I've practiced law. I've defended journalists in Zimbabwe. They still have some very courageous magistrates. The last person I defended, the magistrate acquitted him shortly after his car was bombed. The journalist himself was arrested and deported as he was coming out of court after being found not guilty. So, of course, bills of rights don't work in countries where tyrannies apply. They will, I think, work in Australia, where that kind of behavior is inconceivable. And, of course, they apply. People say, oh, what about the press? What about Parliament? Well, there are thousands of disputes, I suspect, thousands of examples where people aren't being treated properly that the press won't take up, particularly as the press is shrinking in this time of recession, and where Parliament, where MPs won't take up either. At the end of the day, you must have a law, you must have the prospect, at least, of enforcement. That has been the lesson internationally, and it's the lesson nationally as well. It's really, of course, we can be very proud in some ways of our own developments. We are a multicultural society. We have achieved a great deal. But we are, you know, way down in the indices of achievement. We're 39th in relation to press freedom. We just don't have the protection for free speech for newspapers, particularly for business journalism. We still have journalists threatened with jail for not revealing their source. We're way down in the equality indices, in child poverty indices. We're not as good as we think we are in many ways. And so it does seem to me that it is worthwhile to suggest, both on a national level and on a state level, that we have a charter. And this, of course, a charter based on the breakthrough of the Universal Declaration, locating rights, the idea of rights, in the dignity and worth of the human person. That's why, if we bring it home in a statutory charter, its main beneficiaries would be law-abiding citizens whose elderly parents were disabled, or mentally ill relatives, or vulnerable children, ensuring that they're accorded a minimum of dignity and respect. And that's because the moral imperative that Immanuel Kant examined is included and is the basis of the idea. This is an ideas festival, and I want to celebrate the idea of human dignity, which is the basis of charters of rights. It's the basis of the Universal Declaration, and I hope that the consultation process that is just starting, I think it's been through Brisbane, it'll be in other parts of Queensland, will eventually result in an acceptance of this particular idea that human dignity is worth protecting against governments and government agents. Thank you. Yeah, either 10 minutes. We'll see.